Good evening and welcome to Making Your Case, the Art of Persuading Judges, Part 5. Let's get right down to it. We left off last time on Part 21. Close powerfully and say explicitly what you think the court should do. And before we speak about this, I just want to remind everyone this is for entertainment educational purposes only, not to be used for professional, personal, or legal lawful uses at all, not to be construed as financial, professional, personal advice, or anything otherwise. Don't do this at home. And let's continue. Persuasive argument neither comes to an abrupt halt nor trails off in a grab bag of minor points. The art of rhetoric features what is known as the peroration, the conclusion of an argument, which is meant to move the listener to act on what the preceding argument has logically described. The concluding paragraph of a legal argument cannot, of course, be as emotional as a peroration of Cicero's first oration against Catiline, but it should perform the same function appropriately for the differing context. It should briefly call to the reader's or listener's mind the principal arguments made earlier and then describe why the rule of law established by those arguments must be vindicated. Because, for example, any other disposition would leave the bar and the lower courts in uncertainty and confusion, or would facilitate fraud, or would flood the courts with frivolous litigation, and so on. The trite phrase, for all the foregoing reasons, is hopelessly feeble. Something forceful and vivid to sum up your points. Excellent part. So that's how we're going to conclude that first section of this book, and we're on to legal reasoning. So the parts in this are to think syllogistically, to know the rules of contextual interpretation. In cases controlled by governing legal texts, always begin with the words, which I believe that's definitions. Be prepared to defend your interpretation by resort to legislative history. Master the relative weight of precedents, and try to find an explicit statement of your major premise in governing in general. Let's get to it. Section 22. Think syllogistically. Leaving aside emotional appeals, persuasion is possibly only because all human beings are born with a capacity for logical thought. It is something we all have in common. That's a capacity. It doesn't mean that's an ability. The most rigorous form of logic, and hence the most persuasive, is the syllogism. If you have never studied logic, you may be surprised to learn, like the man who was astounded to discover that he had been speaking prose all his life, that you have been using syllogistic reasoning all along. Argument naturally falls into this mode, whether or not you set out to make it do so. But the clearer the syllogistic progression, the better. Legal arguments. Here we go. Take notes. Legal arguments can be expressed syllogistically in two ways. Some are positive syllogisms. Major premise. All S is P. Minor premise. This case is S. Conclusion. This case is P. Others are negative. Major premise. Only S is P. Remember, oops, what do we got here? Oh, there is minor premise. The case is not S. Conclusion. The case is not P. So we get this done right? The major premise, all S is P. This case is P. So if P is a variable for this case, or the symbol for that, we would say that all S, that would be our sample case, is P, the one at hand. Minor premise, this case is S. So conclusion, this case is P. So whatever ruling is for P or S, I guess I'm getting these mixed up, but we get the point here. The negative is the major premise, only S is P. So instead of all, we're using only to the exclusion, inclusivity here. Minor premise, this case is not S. So only S is P. This case is not S. So this case is not P either, right? So this is saying that something doesn't apply. If the major premise, the controlling rule, and the minor premise, the facts invoking that rule, are true, you must establish that they're true. You get that? You must establish this. The conclusion follows inevitably. So the major premise and the minor premise are true. The conclusion follows inevitably. Legal argument generally has three sources of major premises: a text, constitution, statute, regulation, ordinance, or contract, something written, right? A precedent, case law, etc., which is also going to be written, and policy, consequences of the decision. Often, the major premise is self-evident and acknowledged by both sides. So all these seem to be written, expressed in that form. Text, of course, the precedents of case law are in text as well, and the policies are always referred to by their consequence of decision or documented by text too. The minor premise, meanwhile, is derived from the facts of the case. There is much to be said for the proposition that legal reasoning revolves mainly around the establishment of the minor premise. There is much to be said for that proposition. So our legal reasoning revolves mainly around the establishment of the minor premise. So we're getting back to these right here. This case is not S, or this case is S. Negative and positive minor premises here. Okay. All right, let's see, where do we leave off? Okay, yeah, so there's much to be said for the proposition that legal reasoning revolves mainly around the establishment of the minor premise. So we need to establish that premise there. So if you're arguing from precedent, your argument might go, here we go, major premise. Our cases establish that a prisoner has a claim for harm caused by the state's deliberate indifference to serious medical needs. Minor. Guards at the Anderson unit ignored the plaintiff's complaints of acute abdominal pain for 48 hours, whereupon his appendix burst. Conclusion. The plaintiff prisoner has a claim. You get this? Prisoner has a claim. Harms caused by deliberate indifference. Guards ignored plaintiff's complaints of acute abdominal pain, whereupon his appendix burst. That's your minor premise, right? And now we're going to get the conclusion will have to be drawn is the plaintiff prisoner has a claim. So we're going to have to, as we say here, legal reasoning revolves mainly around the establishment of this minor premise that the guards at the Anderson unit ignored the plaintiff's complaints of acute abdominal pain for 48 hours, whereupon his appendix burst. So all these facts need to become true and entered in as evidence. Let's continue. Or if you're arguing text, major. Under the Indian, major premise here, under the Indian Commerce Clause of the U.S. Constitution, states cannot tax Indian tribes for activities on reservations without the express authorization of Congress. Minor premise. Without congressional authorization, South Dakota has imposed its motor fuel tax on tribes that sell fuel on reservations. Conclusion, South Dakota's tax is unconstitutional. Nice. Or if you're arguing policy, major premise, only an interpretation that benefits the handicapped serves the policy of the statute. The minor premise would be the defendant's interpretation of the statute requires each wheelchair-bound employee to buy additional equipment at a cost of $1,800. Conclusion: the defendant's interpretation does not serve the policy objectives of the statute. So that's only interpretation that benefits the handicapped serves the policy objectives of the statute. You get this? Only an interpretation that benefits the handicapped serves the policy objectives of the statute. So the defense interpretation does not serve the policy objectives of the statute. So here we get to the I guess nonfeasance, malfeasance, something of that nature perhaps. Figuring out the contents of a legal syllogism is a matter of finding a rule that works together with the facts of the case. Really, a rule that is invoked by those facts. Typically, adversaries will be angling for different rules by emphasizing different facts. The victor will be the one who convinces decision makers that his or her syllogism is closer to the case's center of gravity. What is this legal problem mostly about? Your task as an advocate is to answer that question convincingly. What is this legal problem mostly about? Good words here. To put an argument in syllogistic form is to strip it bare for logical inspection. We can then see where its weak points must lie, if it has any. And that's from F.C.S. Schiller. And then we have the states, or statutes, regulations, ordinances, contracts, and the like. Okay. Guess that's that part. 23. Chapter 23. Know the rules of textual interpretation. Paramount rule before coming to any conclusion about the meaning of a text. Read the entire document, not just a particular provision at issue. The court will be seeking to give an ambiguous word or phrase meaning in the context of the document in which it appears. Often a later provision will reveal that the earlier provision must bear a particular meaning. Here are the frequently expressed rules of interpretation. Words are presumed to bear in their ordinary meanings. Okay, these are frequently expressed rules of interpretation. Words are presumed to bear their ordinary meanings. Without some contrary indication, a word or phrase is presumed to have the same meaning throughout a document. The provisions of a document should be interpreted in a way that renders them harmonious, not contradictory. If possible, no interpretation should be adopted that renders the provision in question, or any other provision, superfluous, unlawful, or invalid. Hear this one? If possible, no interpretation should be adopted that renders the provision in question, or any other provision, superfluous, unlawful, or invalid. So, important to not interpret certain provisions, if at all possible, as superfluous, unlawful, or invalid. If possible, every word should be given effect. No word should be read as surplusage. Make every word tell. Legislative provisions should be interpreted in a way that avoids placing their constitutionality in doubt. Should. A federal statute should not read to eliminate state sovereign immunity or to preempt state law in an area of traditional state action unless that disposition is clearly expressed, that is outside of an area of traditional state action. Federal statute should not be read to eliminate state sovereign immunity or to preempt state law in an area of traditional state action. Legislative provisions defining crimes and punishments will, in case of ambiguity, be given that interpretation favoring the accused. That's called the rule of lenity. You must also take into account the famous canons of construction. In a particular case, various canons may point in different directions. This does not prove that they are useless, only that all valid clues don't necessarily point in the same direction. It will be your job to persuade the court that most indications from the canons and the principles of statutory construction favor your client's interpretation. The most frequently used canons are the following. Take notes. And pardon my poor Latin. Inclusio unius est exclusio alterius. The inclusion of one implies the exclusion of others. A sign that reads open to persons 21 and over implies that the place is not open to persons under 21. Nascitur sociais. The word is known by the words with which it is associated. In the phrase staples, rivets, nails, pins, and stakes, the word nails obviously does not refer to fingernails, which that would be a synecdoche anyways, wouldn't it? All right. Justum generis, of the same kind. A general residual category following a list of other items refers to items of the same sort. In the phrase staples, rivets, nails, pins, stakes, and other items, the other items don't include balloons, but only other types of fasteners. And I take it things that would pop balloons. Ut magis valiet quam periet, so that it may survive rather than perish. An ambiguous provision should be interpreted in a way that makes it valid rather than invalid. An ambiguous provision should be interpreted in a way that makes it valid rather than invalid, so that it may survive rather than perish. All right. Makes sense. All right. I think we've done enough, and you've endured my Latin enough to allow us to take a little break here on section 24. Governing legal texts always begin with the words of the text to establish the major premise. So while we're thinking about this, let's focus on what we spoke of earlier, the major premise, the minor premise, and the conclusions, both in positive and the negative form, and how we can start to think about looking at logical syllogistic construction for legal cases to increase the readability, understandability, and let's just say the persuasive ability of your motions and such. But again, that's for your choice. This is strictly for entertainment and educational purposes only, not to be construed as legal lawful advice. So don't do this at home. Other than that, I would suggest everyone to definitely hit that notification bell so you can be subscribed of upcoming live streams, as I notice the notifications aren't going out well. But on that, I would like to salute anyone that's been here tonight. I appreciate you guys coming along on this journey of learning how we can make our case and furthering our knowledge in the art of persuading judges. Who knows when that could be valuable for us, but I think in general, making any argument, these are all valid points that we're learning here. So on that note, I would like to salute you all and hope to see you all on the next one. Peace out.